Hello everyone, my name is C. Rohit Grover and I'm a chartered accountant by profession and a qualified CMA. So here I am in front of you and bringing you the CMA Inter-Law Marathon. And the first topic which we are going to deal with today is going to be a director's topic. So what is the name of the topic, everyone? Director's topic. Now, when we talk about the director's topic, first of all, let me tell you the weightage of director's topic in the CMA intermediate level. In the CMA intermediate level, the director topic itself is going to constitute 12 to 15 marks in your examination. And most of the students have fear about this topic. Why? Because they think that this topic is very huge. But let me tell you one thing, this topic is not at all huge. It's very, very simple. It is just that you should have a right approach towards this topic. And other than that, nothing else is required in learning this topic. So I'm expecting you that already you have a little bit idea about the topic called directors. So let us do the revision of the topic called directors without any fail, right? Now, when we talk about the topic called director, the first thing which we have to understand is, sir, what do you mean by the different types of director? Are you getting the point? What do you mean by different types of director? There are so many types of director. There are managing directors, nominee directors, independent directors, women directors, residential directors, executive directors, non-executive directors, small shareholder directors, first directors. Different types of directors are there, right? So first thing we are going to understand is, sir, why directors are required in the company. Try to understand this very clearly. Directors are someone who manages the affairs of the company on the daily basis. Are you getting the point? Now, shareholders are known as the owners of the company. They are known as the members of the company. But directors are the one who take care of the concept or the one who take care of the complete management of the company. So directors are someone who are required to run the company very appropriately and very properly on the daily basis. So what do you mean by the director? Director's definition is given under section number 2, subsection 34. So what is the definition of director, everyone? Read the definition. Definition of director under section 2, subsection 34 says that director is a person appointed as in the board of the company. So you all might have heard about the thing called board of directors. Board of directors is a body under which so many directors are going to participate. And what these directors do, they take the day-to-day decisions of the company like sales, purchase, income, expenditure. Daily matters are going to be handled by whom? Directors. So this is what the definition of director. Director is a person appointed to the board of the company. Now, second thing, why the company to have the board of directors? Now, section number 149, subsection 1 says that the act provides that every company shall have a board of directors consisting of individuals as a director. So major focus in this particular point number 2, which we have to understand that individuals as a director, it means a firm or a body corporate or any partnership firm or any kind of entity cannot become the director. Only a natural person can become the director who is an individual. Is it clear, Emma? So section number 2, subsection 34 says that who is a director? The director is a person appointed in the board of the company, right? And section number 149 subsection 1 says that director is the one who is going to be only and only as an individual. So what are the two things we understood? There is one board of directors, and in the board of directors only individual can be a director. Now, what is the point number 3 says? Point number 3 says that there are different types of directors. What are the types of directors we have? We have women director, we have independent director, we have a nominee director, we have a managing director, we have whole-time director, we have an executive director, we have non-executive director, we have a small shareholder director, we have the first directors. But you need not worry, we are going to understand these different types of directors one by one. Am I clear, everyone? So this is what the definition of the director, which is given as per the Companies Act under section 2, subsection 34 and 149, subsection 1. Now, what is the question number 2? Explain the provisions relating to independent director under Companies Act 2013. First of all, you have to understand one fact that whom do we call as independent director? Independent directors are those directors of the company who only comes in the board meeting, they take their decision and they do not take anything else other than their agreed remuneration. It means other than remuneration, other than their salary, they do not take anything. They are highly impartial, they are highly unbiased, and they are highly independent in nature. It means These directors are very much required in the company if the company wants to take the decisions in an independent manner. So if the company is taking the decisions in the independent manner, they have to hire the whom? They have to hire the independent directors. And nowadays, it has been made mandatory that 1/3 of the company's directors must be what? Independent. So say for example, there are total 9 board of directors in the company. If there is a listed company and there are total 9 board of directors in the company, out of 9 board of directors, 1/3 of the 9 is 3 has to be the which directors? Independent director. So who are independent directors? What are their duration? What is their tenure? That we are going to understand. Now, applicability. Section number 149 subsection 4 provides that every listed company is required to appoint at least 1/3 of the total number of directors as which directors? Independent directors. So what they are saying that if you are a listed company and out of your total board of directors, at least 1/3 should be the which directors? Independent directors. Am I clear, everyone? Any fraction contained will be treated as 1/3. So if you have, say for example, 10 directors, 10 directors ka 1/3 is going to come 3.33. So 0.33 after the 3 will be counted as 1. So it means in that listed company, there has to be the 4 independent directors. Is it clear, everyone? So fraction is going to be considered as 1. Clear? Next point. Following companies means other than listed companies. If you are not a listed company, but you are other than listed companies, when you should have the directors? If you are a other than listed company, at least 2 independent directors are required on your board. But which companies require the minimum 2 independent directors other than listed companies? If those public companies whose paid up share capital is 10 crores or more, those public companies whose turnover is 100 crores or more, and those public companies whose outstanding borrowings include outstanding loans, outstanding debentures, and outstanding deposits. 3 things you have to consider: outstanding loans, outstanding debentures, and outstanding borrowings. So if your outstanding borrowings under that outstanding loans, debentures, and deposits are greater than equals to, or not greater than equals to, the very important word you have to understand here is exceeding 50 crores. Remember, here we are saying that it is 10 crores or more. It means it can be 10 crores or more than 10 crores. Here we are saying that it is 100 crores or more. So in case of paid up share capital provision and in case of turnover provision, it can be 10 crores or more or 100 crores or more. But when we are talking about the outstanding borrowings, where the outstanding loans, outstanding debenture, and outstanding deposits are exceeding, it should be exceeding 50 crores. How much? It should be exceeding how many crores? 50 crores. Is it clear, everyone? Yes. So as a listed company, 1/3 of your directors should be independent directors, and as an unlisted company, if you are a public unlisted company, if your paid up share capital is 10 crores or more, or turnover is 100 crores or more, or outstanding borrowings are exceeding 50 crores, then in that case you need to have at least 2 independent directors on your board of directors. Am I clear? Next one. Every listed company existing on or before the commencement of this act shall comply with the provision of independent director within 1 year from the commencement of this act. They are saying that the independent director concept came in Companies Act 2013. So those companies which were incorporated before Companies Act 2013, as you all might be aware of the fact that before Companies Act 2013, there used to be Companies Act 1956. So before Companies Act 2013, there used to be Companies Act 1956. Those companies have to make sure that they should meet the requirement of their minimum independent directors within 1 year from the commencement of this act. So within 1 year from the commencement of this act, they have to hire the independent directors. Is it clear, everyone? Yes. Next point. The term independent director is what? So section number 149 subsection 6 talks about the independent director. Who is an independent director? Look at this point. Point number 1. An independent director is the one who, in the opinion of the board of director, is a person of high integrity and possesses the relevant expertise. So obviously, independent director should be honest, should be sincere. So we want a sincere person as an independent director, and we want an honest person as an independent director. That is called integrity. Right or not? And who should have a relevant experience? So obviously we don't want any normal person. We want an experienced person on the board of independent directors. Next, and he shall not be a promoter of the company. Remember one thing, he should not be the promoter of the company promoter of the holding company or the promoter of the subsidiary or the promoter of an associate. It means any promoter in the group of holding, subsidiary, associate and your own company is not eligible to become an independent director. So promoter allowed or not allowed? Promoter is directly not allowed to be a which director? Independent director. Next one. It should not relate to the promoters or directors in the company, its holding, subsidiary or associate or company. We are not saying that, see, directly promoter is not allowed, but should not be related to the promoter and directors also. So point number one, what we understood, that he should be a person of high integrity, means honesty, sincerity and relevant experience. Point number two, he should not be the promoter in the company, its holding, its subsidiary and its associate. He should not be related to the promoter and directors of the company, its holding and subsidiary and associate. Did you all understand the point? These are the qualifications to become a which director? Independent director. Next one. It shall not have the pecuniary relationship. What do you mean by pecuniary relationship? Other than your remuneration, you should not have any kind of relationship with the company. You should be only having one relationship with the company, that is called remuneration relationship. Other than that, you should not be allowed to have any kind of pecuniary relationship with the company in the immediately preceding 2 financial years and as well as during the current financial year. So during the current financial year, you should not have any pecuniary relationship with the company, and in the last 2 preceding financial year also, you should not have a pecuniary relationship with the company. Next point, his relatives shall not have. What is the next point, everyone? His relatives shall not have any pecuniary relationship with the company or their promoters of the directors amounting to 2% or more of the gross turnover or the total income or 50 lakhs, whichever is lower. So now we are not talking about the promoter here. Now we are talking about the relatives of the promoter. It means promoter to should not have any kind of relationship with the company. His relatives also should not have any kind of pecuniary relationship with the company. Sir, how much? 50 lakh rupees or 2% of the total turnover or 2% of the total income, whichever is lower, in the immediately preceding 2 financial years. So as a independent director, you should not have a pecuniary relationship with the company in the last 2 preceding financial years or current financial year, or as a relative of the independent director, you should not have done any kind of financial transaction with the company, which should be 2% or of turnover or 2% of the total income or 50 lakhs, whichever is lower, in the last 2 preceding financial year. So their current financial year was there in the point number D. You can see that, but point number E does not talk about the current it talks about the current financial year, and in the point number D also, the both the points may last 2 financial years we are going to talk about, as well as or current financial year also we are going to talk about. Or he or his relative holds or has held the position of KMP or has been an employee of the company or holding subsidiary associate in any of the 3 financial years. Now remember one thing, if you want to become an independent director of a particular company, you or your relatives should not have held any position of KMP, key managerial person, or you should not have been, is or was the employee of the company, its holding, subsidiary, associate in the last 3 years. Next one, he or his employee. He is not an employee. He is not an employee or proprietor. He is not an employee or a proprietor in the last 3 financial years of a particular firm of auditors. Say for example, I am the auditor of one ABC Limited. I am the partner of the auditor ABC and Co. Suppose my firm name is ABC and Co. I am the auditor in one particular company. I am the auditor in one particular company. I am also the partner in that firm who is the auditor of that particular company. I am ineligible to become the independent director. So you should not be the employee or you should not be the proprietor. Again repeating, you should not be the employee, you should not be the proprietor, you should not be the partner in the last 3 financial years, where in the firm of auditors or firm of company secretaries or cost auditors. So you should not be the partner, employee or proprietor in the form of statutory auditors, form of cost auditors and form of secretarial auditors. Or you should not be any partner, employee or proprietary in the legal or consultancy firm. Are you getting the point? Legal or consultancy firm. Next one, you should not be holding together with your relative 2% or more of the voting rights of the company. It means you as an independent director along with your relative should not be holding 2% or more of the total voting powers of the company. Otherwise, you will be disqualified to be a which director? To be an independent director. You are a chief executive or a director of a non-profit organization. Now, see what is this in? Is a chief executive or director of a non-profit organization that receives 25% or more of its receipt from a company or any of its promoter or director of its holding subsidiary associate, or that holds 2% or more of the voting powers of the company, then also you are ineligible. And one last point, who possesses such other qualification as may be prescribed. So what is the overall conclusion of all these points number A to I? The overall conclusion of all these point number A to I is that ki independent director, in their name only the word what is written independent director. So we are not expecting an independent director to be holding more than any of these or holding any of these things in the company. Otherwise, you will be immediately disqualified. So, mota, you should not be a promoter. You should not be related to promoter. Next point, you should not be having any kind of pecuniary relationship. Your relative should not be having any kind of pecuniary relationship of 2% of the turnover or 2% of the total income or 50 lakhs, whichever is lower. Next one, you along with your relative should not be holding any kind of KMP or employee position in the last 3 financial years. Next point, you should not be the employee, proprietor or partner in the legal firm, consultancy firm, in the auditors firm, secretarial auditors firm, or what do you say, cost auditor firm. You along with your relative should not be holding 2% of the equity paid up share capital of the company, and along with that, that is voting right. And you should not be the chief executive officer or a director of any NPO which is receiving 25% or more of its receipt from a company where you are already a promoter or director. Did you get the point? And who should possess the other things? Next point. Sir, what is the tenure of the independent director? What is the tenure of the independent director? Remember one thing, independent director can be appointed for 5 years. Independent director can be appointed for 5 years. It means the one term of the independent director is for how many years? 5 years. Sir, can he be reappointed again? Yes, he can be reappointed again for the second term, but only by passing a special resolution. So his normal term consisting of how many years, everyone? 5 consecutive years. He can be reappointed again for the second term, but only by passing a resolution. It means 5 plus 5, continuously one independent director can serve the company for 10 years, but generally one term of 5 years, but second term of 5 years he can be reappointed again in the same company by passing a which resolution? By passing a special resolution. Is it clear to all of you? Yes, everyone? Yes. Next point. No independent director, what is written? No independent director shall hold the office for more than 2 consecutive years. It means after 2 terms of 5 years each, you are not allowed to hold the third term again. And one more thing, once you retire as an independent director, there is a cooling period. Means, what do you mean by cooling period? You are not allowed to come back to the same company in any kind of relationship for the next 3 years. So there is a cooling period of how many years, everyone? There is a cooling period of 3 years. Are you getting the point? Next point. The provision of retirement of directors shall not be applicable to independent director, because independent director is different from the normal directors. So like normal director retire by rotation, he does not retire by rotation. He has to complete the one term of 5 years. Second term, he can be appointed again for the 5 years, but by passing a special resolution. So appointment of independent director shall be approved by the company in which meeting? General meeting. Clear, everyone? So this is what brings an end to the very, very important topic called what? Independent directors. Right, everyone? Now, next thing which we have to understand that is, sir, different types of directors we have to understand. The first director which we are going to understand is known as women director. Now, remember one thing, section number 149 subsection 1 has made it mandatory that if you are a listed company, if you are a which company, you are a listed company, you mandatorily have to have at least one women director. You mandatorily have to have at least one women director. So if you are a listed company, mandatorily one women director is required. Or if you are an unlisted public company and if your paid up share capital is 100 crores or more, it means greater than equals to 100 crores. Or if your turnover is greater than equals to 300 crores, then also the independent women director becomes what? mandatory. Are you getting the point or not? So remember one thing, if you're a listed company, women director is compulsory. If you're other than listed company and your paid up share capital is 100 crores or more, or turnover is 300 crores or more, then in that case, the women director becomes what? Compulsory in your organization, even though you are not a listed company, but you should be a public company. It means in the private company, do we need independent director? No. In the private company, women director is required or not required? Women director is not required in the case of what? Private company. Now the question is sir, there was one women director in our company. That women director left our office. She resigned our office. Now who is going to fill up the casual vacancy of that women director? By the board of directors, but not later than immediately next board meeting or 3 months from the date of vacancy, whichever is later. Now let's say for example, there was Mrs. X who was in women director. She left. Are you getting it? She left. She resigned. Now, who is going to fill up the casual vacancy on the behalf of Mrs. X? Board of directors. Not later than the next board meeting. It means the next board meeting they will wait, or maximum 3 months they will wait, whichever is later. Are you getting the point? So it means the next women director has to be appointed not later than next board meeting or the 3 months from the such vacancy, whichever is later. This is what the provision related to women director under section 149 subsection 1. Now next point, independent director, that we have already covered above, the qualification, the tenure, everything about the independent director. Now question is nominee director. Now what do you mean by nominee director? Now let's say for example, some of the banks and financial institutions gives you a lot of money. Obviously they lend you a lot of money, they lend you a lot of what? Loans. At that point of time, they are really interested in knowing whether the company is utilizing the funds or misutilizing the funds, but they are not carrying any voting rights. That's the reason those banks and financial institutions are going to send their nominee director on the company to keep an eye over the company for the better utilization of the funds. So that director, which is nominated by the financial institutions for the time being enforced by doing some agreement with the company and appointed by the government, appointed by whom? Government. Then in that case, that person is known as which director, everyone? Nominee director. So nominee means he is nothing but representing those banks and financial institutions which have given you a lot of money as a loan. So he's basically keeping an eye. Now, what is the next definition we have to understand? Managing director under section 2 subsection 54. Now remember one thing, managing director mean, let's talk about the first thing. Let's keep the word managing aside and director aside. Managing means the one who is in the continuous employment of the company. Along with that, he's also a director. So he's an employee as well as the director. But what makes the managing director different from the board of directors? What makes this managing director different from the board of director is major substantial powers. Major substantial powers of the company are in the hands of whom? Managing director. Normal board of directors take care of the day-to-day operations, but managing director takes care of the substantial powers of the company. Which powers, everyone? Substantial powers of the company. Now see, the term managing director is a director who, by the virtue of the article of association or agreement with the company or the resolution passed in the general meeting. So managing director can be appointed in 3 ways. Point number 1, either you can mention the name of the managing director in articles of association, or you can enter an agreement with someone to appoint him as a managing director, or you can pass a resolution to appoint a managing director in a general meeting. By whom? By the board of directors. First of all, board of directors are going to appoint the managing director. So we generally think that managing director is bigger than board of directors. Yes, he is having the most substantial power as compared to the board of directors, but he is actually appointed by the board of directors either by mentioning his name in articles, or by entering an agreement with the company, or by taking the permission of the shareholders by passing a resolution in the general meeting. And what is a major thing which makes him different from the board of director? He holds the substantial powers of the. Is it clear? This is what do you mean by which director, everyone? Managing director. Now the next question is, Whole-time director. From the name itself only, you can understand what do you mean by whole-time director. The one person who is a director in the company as well as in the whole employment, whole-time employment of the company. He is a full-time employee of the company as well as a director of the company. That person is known as whole-time director. The whole-time director as including a director in the whole-time employment of the company. Now, next thing, appointment of the director elected by the small shareholders. What do you mean by appointment of the director elected by the small shareholders? Now listen to this point very carefully. Small shareholder means what? Small shareholder is that person who is holding not exceeding 20,000 rupees of nominal value of the share capital of the company. Are you getting the point? The small shareholder is the one who does not hold more than 20,000 rupees of nominal value of the shares in the company. Are you getting the point? And if you are now, these are the small shareholders. Now, most of the times, small shareholders will be neglected in the meetings. But we don't want those small shareholders to be neglected in the meeting. We want one representative. We want one representative who will represent these small shareholders in the board meeting. We want one representative of the small shareholders who will represent these small shareholders in the board of directors meeting. Are you getting the point? So that's the reason we have to appoint one small shareholder director representing small shareholders in the board of directors. And if you are a listed company, one small shareholder director is compulsory. So see, is case who is a small shareholder, the one who is not holding the nominal value of the shares more than 20,000, as a listed company must have a one director elected by small shareholders. Now, what do you mean by this small shareholder? Every listed company requires this small shareholder, but how? Either upon a request made by the 1,000 small shareholders or 1/10 of the members of the small shareholders, whichever is lower. It means a listed company has to appoint a one small shareholder director, which will be requested by either 1,000 small shareholders or 1/10 of the total such shareholders, whichever is what lower. These are the people who will request the company, and that person will be appointed as a director in the board of director who is representing small shareholders, right? But the good thing with this director is he need not retire by what? Rotation. Like an independent director, this director also need not retire by what? Rotation. The tenure shall not exceed a period of what? 3 consecutive years, and on the expiry of the tenure, such director shall not be eligible for reappointment. Now, this point makes him different from the independent director. Independent director's tenure was 5 years. His tenure is 3 years. Independent director can be reappointed again for a next tenure of 5 years by passing a special resolution, but he cannot be reappointed again for the next tenure. Did you get the point? The disqualified person for the appointment of the director shall not be eligible for such appointment. If you are a director disqualified under section number 164, you are not eligible to be appointed as a small shareholder director. So your disqualification will not allow you to become a small shareholder director. Next one. No person shall hold the position of the small shareholder director in more than 2 companies at the same time. It means you can become the small shareholder in one company and you can become the small shareholder director in another company. But more than 2 companies allowed or not allowed? Not allowed. How many companies maximum allowed? 2 companies are allowed maximum. More than 2 companies may you cannot become a small shareholder director. Next one. A small shareholder director shall not, for a period of 3 years from the date on which he ceases to hold an office, director in the company be appointed or associated with such company in any other capacity, either directly or indirectly. Means once you left the company as a small shareholder director, from the date of ceasing to be a small shareholder director, for the next 3 years, you are not allowed to have any kind of relationship with that company which you recently left, either directly or indirectly. That makes you a small shareholder director. Is it crystal clear? Yes. Now, next question, sir. Who are known as the first directors? First directors are those directors who are named in the articles of association. Are you getting the point? Now, generally, they are those directors who are named in article of association. Section 152, subsection 1, where there no provision is made in the article of association for the appointment of first director, the subscribers to memorandum who are the individual shall be deemed to be the first directors of the company until the directors are duly appointed. You know that we need 7 subscribers to make a public company. We need 2 subscribers to make a private company. Am I correct? Now, if the article of association mentions someone as a first director, it is fine. We will take that person only as a what? First director. But if the article of association does not mention any first directors, then the subscribers to memorandum, who are the first 7 members of the public company and the first 2 members of the public company, will be treated as first directors of the company. Clear? In one-person company, an individual being a member shall be deemed to its first company. You know that in the one-person company, minimum and maximum number of members are 1. Therefore, that 1 member only will be deemed to be a first director of the company. Is it clear, everyone? Next one. Who is additional director? Now listen to this point. Who is known as additional director? Additional director means, suppose when the company is not capable of being run by the sufficient number of directors, they think that we need more number of directors. In such cases, companies may appoint the additional directors. Now see, section 161 subsection 1 provides that the article of association of the company may confer on its board of director the power to appoint any person other than a person who fails to get appointed as a director in the general meeting as an additional director. The board of directors, if they think that they do not have sufficient number of directors onto the board of directors and they are feeling the lack of number of directors, the board of directors can appoint additional directors. But remember, the one who is disqualified under section 164 is not allowed to be the additional director. Clear? Such a director shall hold the office up to the date of next AGM or the last on which the annual general meeting should have been held, whichever is earlier. So what is the duration of these directors? Up to the next AGM or the annual general meeting held, whichever is what going to be held, whichever is earlier. Now, what do you mean by alternate director? Say, for example, there is one director who went outside India. There is one director who went outside India. Now, we need to conduct a board meeting. And due to that particular director who went outside India, we are unable to conduct a board meeting. So, we will appoint an alternate director. We will appoint an alternate director. But sir, how we can appoint an alternate director? This alternate director is going to be appointed on the behalf of that director who went outside India. Are you getting the point? But let me tell you one thing. He cannot be appointed for less than 3 months. Now, let's say, for example, there is one director who went outside India. Say, for example, he is in United States. And that director requirement is there in India. So, section number 161 subsection 2 tells to the board of directors, yes, you can appoint an board of director, you can appoint one alternate director in place of that director. But remember one thing, board of directors will appoint, but later on it is required to be approved in the general meeting and your article of association should also authorize it. Now see, section number 161 subsection 2 provides that board of directors of the company may, if so authorized by the articles or by the resolution passed in the general meeting, appoint a person not being a person holding any alternate directorship or any other directorship in the company to act as an alternate director for a director during his absence for a period not less than 3 months from India. So let's say, for example, if Mr. A left India, that is United States, if Mr. A left India for a United States for 6 months, then alternate director is required. If we left for 4 months, alternate director is required. But if we left for 2 months, then alternate director is not required because the original director should have left India for at least 3 months or more. Then only alternate director is required. Is it clear to every one of you? Yes or no? Yes, it is perfectly clear. Question is, the alternate director should not be the alternate director for anybody else already in the company. He should not be the alternate director of anybody else already in the company, or he should not be a normal director. It means a normal director of the company cannot be appointed as an alternate director for the another director. Means that director who is already a director in the company cannot be appointed as an alternate director, and he should not be already a alternate director of anybody else. Right or not? So point number 1 mein what we understood, first of all, board can appoint, authorized by articles, approval in the general meeting, and the director on whose behalf we are appointing this alternate director, that must have left to India for at least 3 months or more. He should not be the already a present director of the company, and at the same point of time he should not be already a alternate director of any other director. That brings an end to your types of directors ka revision. I hope all of you are understanding. Next point, discuss the procedure for the rotation of directors and reappointment of directors. Now see, what do you mean by rotation of directors? This is that key at every annual general meeting, at every AGM, at least two-thirds of the directors, two-thirds of the total number of directors must retire by rotation. Are you getting the point? Two-thirds of the directors in the AGM, every AGM must retire by rotation. But this provision is only and only applicable to public companies. Which companies, everyone? Public companies. It is only applicable to public companies. Now, see, unless the articles provide for the retirement of all directors at the every general meeting, not less than two-thirds of the total number of directors shall be a person whose period of office is liable to be determination by retirement of directors by rotation, and save as otherwise expressly provided in the act be appointed in the general meeting. Means what? If the article of association says something else, then we will follow article of association. But if the article of association is silent, that not less than two-thirds of the directors in every AGM must retire by rotation. Clear? The directors to retire by rotation at every AGM shall be those who have been longest in the office since their last appointment, but as between the person who became the director on the same day, those who are retired shall in default or subject to agreement among themselves be determined by law. They are saying that which directors are going to retire. So tell me one thing, the youngest one, the one who recently appointed, or the oldest one should be retiring first? The oldest one should be retiring first. Did you get the point? The one who has already served the longest period as a director, they should retire first. Next one, the company may fill up the vacancy by appointing the retired director or some other person there too. So obviously when the directors will retire, the place will be vacant. The company will fill up the, what do you mean by company? We will fill up the place by the shareholders in the general meeting. You all know that in the AGM, one of the four ordinary businesses are appointment and removal of directors also, right? So we will appoint it. Next one, reappointment of the director. Now see, a director is liable to be retired, may be reappointed in what? General meeting. Suppose you are about to get retired in the general meeting. You are among those two-thirds of the directors who are going to get retired in the general meeting. You are again liable to be reappointed again. Means what? You are a director liable to retire by rotation, can be reappointed again in the general meeting. No person who is or has been a director of the company, section number 140, section number 164, subsection 2. Now listen to this point very, very carefully. This is a very important point. Now listen. There are very two important documents of the company. One is known as financial statement and one is known as annual return. Financial statement comes under section number 137. Annual returns comes under section number 92. Both are required to be filed with whom? ROC. Both the documents are required to be filed with ROC. Financial statements are required to be filed with ROC within 30 days from AGM. And annual returns are required to be filed with ROC within 60 days from AGM. Right? But continuously for 3 years, if the directors have done this default, means neither they filed financial statements nor they filed annual returns for continuously how many years? 3 years. It means they have done the default for continuously 3 years. Then section number 164 subsection 2 says that you are not eligible to be appointed as a director in the company for the next what? 5 years. This is called special disqualification. This is called which disqualification? Special disqualification. So say for example, if you were a director for the 3 years when neither the financial statements were filed with ROC nor the annual returns were filed with ROC for continuously how many years? 3 years, then you will be disqualified to be a director in that company under section 164 subsection 3. And there is one another provision. Suppose your deposits are matured, your debenture holders are matured, your interest is pending. Obviously, outside liabilities you have to pay first. But suppose you did not repay their money back or you did not pay their interest, and this continued for what? 1 year. Now see, in the above case, it is that default of the financial statement and annual return will be counted for 3 years. But here the default is for 1 year. In both the situation, section number 164 subsection 2 disqualifies you to become a director again for the next what? 5 financially. Now see, no person who is or has been a director at the time of company has not filed what? Financial statement 137, annual returns 92 for a continuous period of what? 3 years, or has failed to repay the deposits accepted by it or pay interest or redeem any debentures on the due date, and this thing continues for a period of 1 year, shall be eligible to be reappointed as a director or appointed in the company for a period of 5 years from the date on the said company fails to do so. And not only in this company you are disqualified for 5 years, you are disqualified to be an director in any other company for the next what? 5 years. Did you get the point? This is a very important disqualification under section 164 subsection 2. Again repeating, if you have not filed financial statements and annual returns continuously for 3 years and you were a director during those 3 years when this default was going on, you will be disqualified to be appointed in that company or in any company for the next what? 5 years. Your debentures are not repaid, your deposits are not repaid, your interest is not paid for continuously 1 year, and you were present as a director during that default, then in that case, what will happen? In that case, again, you will be disqualified under section 164, subsection. Next point. Director identification number. Discuss the provisions relating to. Now, what do you mean by DIN number, everyone? DIN number stands for Director Identification Number. DIN stands for what? Director Identification Number. Now, what do you mean by Director's Identification Number? What do you mean by Director's Identification Number? Now, what do you mean by Director's Identification Number? Director's Identification is a allocation of the identification number given under the Companies Act by the ROC, basically by the central government, to identify that this particular director must quote this number in whatever the companies he wants to become a director. First of all, I should tell you that one director can become a director in 20 companies. One director can become the director in 20 companies. So he can hold the directorship in 20 companies. But whatever the company is holding the directorship, he has to quote one DIN number. What is DIN? Director Identification Number. Like we have the SIN for the company, Corporate Identification Number, which we get it on our certificate of incorporation. So Ministry of Corporate Affairs has made it mandatory that directors also have to obtain DIN. And you will be glad to know that the very first DIN of India is with the Ratan Tata, that is 000001. The first DIN of India is with the Ratan Tata, right? After that, the DIN concept has become so much popular in India that now every director without obtaining DIN cannot be the director in a company. This is called Director Identification Number. Is it clear, everyone? Now, you all know that for a private company, we need at least 2 directors, and for the public company, we need at least how many directors? 3 directors, and maximum we can have 15 directors only in a company. But if you want to have more than 15 directors, you need to pass a resolution. Don't mix this thing with this. Here we are talking about the number of directors of a company. What I am telling you that if one director can become a director in 20 different companies. But wherever the company he will become a director, he has to quote his DIN number, Director Identification Number. Is it clear to all of you? Yes? Yes. Now see this topic. Every individual who is going to be appointed as a director of the company shall make the application in form number DIR 3 to the central government for the allotment of DIN number. So it means you have to open an application DIR 3, you have to apply to the central government, put your credentials, and you can apply for the DIN. The applicant can download the said form from the website of Ministry of Corporate Affairs. So Ministry of Corporate Affairs ka website is mca.gov.in. You can go there, you can download DIR 3, fill up your details, and you can upload it electronically, and you can sign that form digitally as well, along with your photograph. So you can download this from the website and you can sign it with your digitally and along with your photograph. Am I clear, everyone? The form shall be verified by a chartered accountant in practice or a company secretary in practice or a cost accountant in practice. You need to get this form verified by either a practicing CA, practicing CS, or practicing CMA, which form DAR 3. Now, once the application is made, the system shall generate an application number. So, obviously, you have submitted an application, one application number will be generated. Central government shall process the application and decide the approval or reject it. So, obviously, your application is now filled up with the central government. They will do the processing. They will see whether to accept your application or to reject your application, and they have to ultimate communicate the same to the applicant. Are you getting the point? And how they are going to communicate? They are going to communicate either physically or electronically within 30 days from the receipt of application. So within 30 days, you will get a mail or you will get a post from the MCA whether your DIN application has been accepted or rejected. So point number 1, form number is DIR 3 to be filed with central government on the website called mca.gov.in. By downloading it with your photographs, digitally signed application for the DIN should be verified by a practicing CA, practicing CS, or practicing cost accountant, and make sure that once this application is made, government will do the processing, will intimate you within 30 days whether your application is accepted or application is rejected. Now, suppose in case in your application there is some problem, they will intimate you that problem via mail, and you have to make sure that you are rectifying that problem within 15 days from the date of intimation you received from the Ministry of Corporate Affairs. See, if any defect is found in the application, they shall give the intimation of such defects to the applicant by placing it on the website. Either they can put your name on the website and tell you that what is a problem in your form, or they can send you via mail. The applicant shall rectify this within 15 days. If within 15 days the same has not been rectified, the government shall reject the application to the fresh application. In case of rejection or invalidation, fees so paid application shall be neither be refunded nor adjusted with any other application. If within 15 days you do not remove your defect, then government will reject your application and no refund is allowed. Right? DIN allotted to the director before the commencement of this act shall be deemed to be the DIN allotted under the present act. DIN allotted shall be valid up to the lifetime of the director. So what is the validity of one DIN? Validity of one DIN is lifetime, and you can quote it in the 20 different companies wherever you are going to hold a directorship. Am I correct? Like a PAN number we have, same is the case with the DIN number. Difference is it is called director identification number. Now you got the allotment of DIN. Say for example, the director on the allotment of DIN is to intimate the company in form number DIR 3C. So say for example, you applied in DIR 3, you got the DIN number from the central government. Now you have to intimate your DIN number to whom? To the company in the form number DISC, DIR 3C within 15 days from the intimation given to him. So the moment you receive the intimation that about your DIN number, you have to intimate the same to whom? To the company. Are you getting the point? In form number DIR 3 capital C. Now, if you are not intimating to the company, company within 15 days of your intimation must furnish the same DIN to ROC. So you are intimating within 15 days, and every company within the next 15 days, the moment they received from you, in the next 15 days, they have to intimate that to the ROC. But if the company fails to furnish the DIN to the ROC, what is the penalty on the company? It should not be less than 25,000 but may extend up to 1 lakh rupee. And every officer in default who was responsible for that will not be less than 25,000, may extend up to 1 lakh rupees. So either it is a penalty on the company or it is a penalty on the officer, and default penalty will remain same. So DIN is very important to be quoted by you to the company in DIR 3 capital C and company to the ROC. In both the cases, time period is 15 days. Right, everyone? Now, section number 159 provides that if any individual or director of the company contravenes any of the provision of 152, that is called appointment of directors, 155, that is called prohibition to obtain more than one DIN, and obviously you can obtain only one DIN, you cannot obtain multiple DINs, and 156, director to intimate or DIN. Such individual or director shall be punishable with an imprisonment of a term which may extend to 6 months, or a fine which may extend up to 50,000. Remember, company is already punished for not intimating to ROC. Officer in default is already punished for not intimating to ROC. But if you are doing any violation of these sections, section number 152 violation, or section number 155 violation, or section number 156 violation, so you are going to jail up to 6 months, or you will end up paying the fine up to rupees 50. And if you are doing this offense again and again, 500 rupees per day. How much? 500 rupees per day. You have to pay. Clear, everyone? So this is what brings an end to your DIN application, everyone. Which application? DIN application. Now the next very, very important question. If you remember, just now I told you section number 164 subsection 2. 164 subsection 2 was talking about the special disqualifications. Non-filing of financial statement and what do you say, annual returns with whom ROC, that I told you. And along with that, I also told you non-repayment of the outside funds. Am I correct? No, all these things I told you. So now we are going to do the general disqualifications under section 164. Now, what are the general disqualifications of the director under section 164? He is of a unsound mind and stands so declared by competent court. If you are a person of unsound mind and you have been declared as unsound by the competent court, you are disqualified to be a director. Insane person is not eligible to be a director in the company. Next one. If you are undischarged insolvent, means what? You are insolvent and so far you have not discharged your insolvency. So far you have not discharged your liabilities. You are still undischarged insolvent. You are disqualified to be a director. In case you have applied to the court to declare you as an insolvent and your application is pending, then also you are going to be treated as insolvent and you are disqualified to be a director. Is it clear, everyone? Now, what you have to understand that when you are disqualified, point number one, if you are declared insane or if you are declared insolvent by the competent court, if you are undischarged insolvent and you have applied for the insolvency and your application is pending, in all these cases you will be disqualified from being a director of the company. Or next point, he has been convicted for an offense either involving moral turpitude. Say for example, you were sent to the jail for an offense of a moral turpitude, where you were sent to the jail for imprisonment minimum 6 months. If you have gone to the jail for less than 6 months, you are still qualified. But if you have convicted for an offense containing moral turpitude, or you were sent to the jail for not less than 6 months, it means minimum 6 months you were in the jail. At that point of time, you were imprisoned for minimum 6 months. And from that date, minimum 5 years have not elapsed, you are disqualified to be a director. It means even though you have served your imprisonment. Suppose you were sent to the jail for 7 years. Sorry, you were sent to the jail for 8 months and you went to the jail for 8 months. After 8 months, it doesn't mean that you are eligible. You still have a ban. You are still disqualified for the next 5 years. So period of 5 years should elapse. After that, you will be again requalified again. Did you get the point? A person who has been convicted for an offense sentenced to the imprisonment for a period of 7 years or more, he shall not be eligible to be appointed as a director in any company. See, in the earlier D case and E case, my difference is what? In the E case, they are saying that if you have been convicted for an offense where you were sent to the imprisonment for 7 years or more, you are permanently disqualified, not only in this company, in any. More than 6 months ke case mein, still there is a ban of 5 years. After 5 years, there is a possibility that some companies may appoint you as a director. But in this case, no possibility. You will not be elected as a director. Is it crystal clear to all? Yes or no? Yes. Next one. An order disqualifying him for the appointment as a director has been passed by the court or tribunal or order in force. Suppose the court has disqualified you or the NCLT has disqualified you, then also you are disqualified to be a director. Or in case you have not paid your calls on time. In case you are not paying your calls and 6 months have elapsed, still you are pending with your calls, you are disqualified. Are you getting the point? You have to pay your call money, and if the 6 months have been elapsed from the last date for the payment of what? That call money, you will be immediately disqualified. Next point, if you have been convicted for any offense relating to related party transactions in the last 5 years. So if you were convicted by the court for an offense relating to related party transaction, section 188, they are called as fraudulent transactions which you do with the related party. So for example, holding company has done one fraudulent transaction with a subsidiary. It is known as a related party transaction. In the last 5 years, if you were convicted for any kind of offense relating to related party transaction in the last 5 years, you are again disqualified, or if you have not obtained any TIN. Now, last point mein they are saying that these disqualifications are equally applicable to private company also, but if the private company want, they can add some more disqualifications also. Did you get the point or not? So that brings an end to your section number 164 ka disqualification. Now, what they are saying, now listen to this one. They are saying that point number D, they are saying that point number D, point number E, point number F, and point number H. What is point number D? Convicted for an offense of minimum 6 months, then 5 years ban. What is point number E? Convicted for 7 years or more, permanent disqualification. Point is point number F, you have been disqualified by the court or tribunal or any order in force. And what is the point number H? Related party. So 6 months or more, 7 years or more, what do you say? Order was passed by the court or tribunal, or you can say that related party transaction. In all these cases has happened. These cases, they are saying that the disqualification shall not take effect for the 30 days from the date of conviction or the order of what? Disqualification. They are saying that there may be a possibility you are still fighting a case. For the first 30 days, we will not disqualify you. We will allow you to be a director. For the first how many days? 30 days from the date on which this order has been passed against. Where an appeal or petition is preferred within 30 days against the conviction resulting in sentence until the expiry of 7 days from the date on which such appeal is disposed of. Suppose within 30 days, if you have filed an appeal, within 30 days, if you have filed an appeal, I am not convicted, I am against this particular order of the government, then in that case, till the time that appeal is going on, you are still qualified, you are not disqualified, and 7 days from the such appeal or petition is disposed. It means once the appeal is disposed, still for the next 7 days also you are not disqualified. Where any further appeal or petition is preferred against the order within 7 days until such appeal or petition is disposed. So say for example, 1st January 2022, you were sentenced for 7 years. Now within the next 30 days, you filed an appeal. Where High Court, say for example, you filed an appeal in High Court. High Court took 3 months to dispose your appeal. So say for example, on 10th April 2022, the High Court has disposed your appeal. Still, you have 7 days. For the next 7 days, you are still qualified to be a director. In these 7 days, say for example, you have made a second appeal. You made a which appeal? You made a second appeal, and till the time your second appeal is not getting disposed, you are still qualified. It means your disqualification will not attract in the first 30 days. In the first 30 days, you appealed, the time of appeal, and the 7 days after the appeal is disposed, you are still a director. And within those 7 days, if you have still filed a further appeal, that is second appeal, till the time your second appeal is not getting disposed, you are still an director of the company. This is what brings an end to your section number 164. Very important section, that is called what? Directors of the company. Is it clear to all of you? Right? So this particular topic called directors of the company, we have already covered almost up to section number 164. We are left with section number 167, and we are left with section number 169, that is called removal. 167 talks about vacancy, 169 talks about removal, and along with that, we have to do the basic remunerations and patch-up work relating to remuneration paid to the whole-time director, managing directors. This topic is left, and along with that, that is section number 197, basically remuneration 196 and 197, and we have to talk about the sitting fees and all those things which are not becoming the part of remuneration. And next, more important, what are the duties of the directors as per the Companies Act, and what are the powers of the directors as per section number 179, and explain briefly the restrictions on the powers of directors, section number 180, 181 contribution towards a charitable fund, and 182 then the prohibition and restriction regarding the political contributions. These are the various sections and procedure for the resignation of director, that is called 168. The 167, 168, 169, 190, 179, 180. These are the residual topics we are left with. So this is what we are going to understand in our part number 2, everyone. Is it clear, everyone? So up to section number 164, what we have understood just now, okay, how the directors are appointed, what are the different types of directors, then we understood independent director, and then we understood the disqualifications of the directors. So all this up to section number 164 we are done with. The remaining sections we are going to understand in our next session. So thank you so much for lending your patient ears. I hope you enjoyed the marathon on the first part of directors. Yes, so see you guys in the next video. Thank you so much, everyone. Bye bye, take care.